In January 2025, the President signed Executive Order 14160. The directive targeted a specific, highly controversial goal: denying U.S. citizenship to children born on American soil to undocumented immigrants or parents holding temporary visas. That signature immediately triggered a wave of civil rights lawsuits. One specific case, Trump v. Barbara, successfully halted the order in its tracks. Now this legal war is heading for its ultimate climax. In April 2026, the Supreme Court will hear oral arguments to decide the order's fate. This case is a direct battle over who holds the power to define an American at birth. The Supreme Court is the final arena where this constitutional clash will be resolved. The administration's defense is being led by Solicitor General D. John Sauer. He argues that birthright citizenship requires an American baby's parents to have legal domicile and recognized status in the United States. The counter-argument points directly to the bedrock text of the Constitution itself, the 14th Amendment. It states that all persons born or naturalized in the United States are citizens. To win this case, the administration must convince the court that a century-old legal interpretation of that amendment and a very specific federal law passed in 1952 are entirely wrong. The defense's biggest hurdle isn't constitutional history, it is a specific federal statute, Title 8, Section 1401A of the 1952 Immigration and Nationality Act. This image displays the exact text of the 1952 law defining who is a national and citizen at birth. It reads, "A person born in the United States and subject to the jurisdiction thereof." Look closely at that sentence. You will not find the words parent, mother, father, or domicile. They simply do not exist in this section of the code. This gets especially interesting when you look at the rest of the 1952 Act. Several other sections dealing with children born overseas explicitly mention parents, mothers, and fathers. Congress deliberately left parentage out of Section 1401A. On U.S. soil, the law is based purely on geography. In legal terms, this is known as jus soli, or the law of the soil. To test how strictly the law applies jus soli, we can look at a very specific edge case written into both the 1940 and 1952 Nationality Acts, the foundling provision. If a child of unknown parentage is found within the U.S., they are automatically presumed to be a citizen. The logic is unavoidable. If legal parentage was required, a foundling could never be a citizen, because their parentage is a blank slate. This statutory logic maps perfectly onto the monumental 1898 Supreme Court ruling in United States v. Wong Kim Ark. That decision cemented the principle that birth within the nation's dominion equals citizenship. The foundling provision acts as a mathematical proof. It demonstrates that under the text of the law, a child's parentage is legally invisible to the soil they are born on. The American legal system has been pushed to abandon this principle before. Following the entry into World War II, the country was gripped by intense national security anxiety and nativist panic. In the midst of this panic, lawyers saw an opportunity. They went to court to strip birthright citizenship away from Japanese Americans. But the federal courts in the 1940s refused to bend. Explicitly citing Wong Kim Ark, judges threw those cases out, stating clearly that the rules of citizenship do not change during a crisis. The executive branch held the exact same line. In a 1938 report to Congress, the Roosevelt administration explicitly stated that birth, not the domicile of the parents, determines nationality. Even under the most extreme pressure the nation has faced, the legal system absolutely refused to replace the law of the soil with the law of the bloodline. All of this legal history brings us directly to the impending Supreme Court decision arriving in April 2026. To rule for the administration, the court must dismantle a towering structure of precedent. Specifically, the justices would have to legislate from the bench, inserting the word parents into a 1952 statute where Congress purposefully left it out. By the summer of 2026, the Supreme Court will deliver its final answer. They will decide whether to honor the literal letter of the law or rewrite what it means to be born in the USA.